Hi, this is Judge Herb Dodell. Every case that's ever tried consists of evidence. We talked about evidence not too long ago. Now, there are different types of evidence. Some give them greater weight than others. One is called direct evidence. Direct evidence is you see it. You can describe it, you can feel it, you can touch it. It's right there for you. That's direct evidence. The other evidence is called circumstantial evidence, where you have to draw an inference from a fact. The fact itself doesn't do it, but it gives you enough information from you to conclude that based on this circumstance, this is what the end result would be. It's like the kid who's lying in bed with strawberry jam on his lips, and you go downstairs and you find out in the refrigerator somebody went and hit the jam bottle and cleaned it. Well, who did it? Well, the circumstantial evidence is found on the boy's face or the girl's face, showing that that's what had happened. So if there is a failure, it's like a chain. Circumstantial evidence is a chain. Each has a link, and there are many links. And so if there's a significant piece of information in the links that falls apart, an alibi, something to justify or explain it or weaken it or affect its credibility, that link, if you take that link out of the chain, what happens? You can't hook the remaining links together. There's a missing space in between. And when you knock off part of the circumstantial evidence, it affects the ultimate outcome. It has to. There's no question about it. And so if you have a case where someone is accused of a crime and they were in Cincinnati at the time and you could prove it, that's a link in the chain that might not work. It falls out, case falls out. More of those links that fall out, the less credible the outcome is going to be. It was like even in the Manafort case. They didn't put on a defense. Why not? Because they probably didn't have one. But they attacked the circumstantial evidence, and circumstantial evidence depends a lot on the credibility of the witness offering that evidence. In Manafort, for example, the star witness for the prosecution was apparently a problem. I don't know enough about the facts. I didn't hear the testimony. But obviously, if you can attack and beat the credibility of the witness offering that testimony, that evidence, that circumstantial evidence, that's how you win cases, because then you've established what's known as reasonable doubt. In a civil case, basically the same, except the burden of proof is a little different. The burden of proof is by a preponderance of the evidence, meaning more likely than not as strong as beyond a reasonable doubt. So most cases deal with circumstantial evidence. Watch for the attacks on each of these links and always think of it as the chain, and without the links, ain't no chain.